Excellences, Mesdames, Messieurs, bonjour. J'ai l'honneur d'ouvrir et de présider cette première journée de travail de ce congrès mondial sur la justice juvénile. Je suis impressionné par le nombre de représentants d'États, mais également d'organisations non gouvernementales et de particuliers du monde entier présents ici à Genève. C'est pour moi un signe que cette thématique est mûre d'avancer de grands pas. Je vous souhaite la bienvenue dans cette démarche. J'espère que vous profitez de cette première journée et que vous aurez l'occasion chaque jour de ce congrès de vous enrichir de quelques pistes de réflexion. Permettez-moi de vous rendre attentif à un point crucial. Nous avons devant nous un programme chargé et dense, mais surtout un programme réjouissant. En tant que président de séance, j'ai également pour tâche, non des plus faciles, de veiller au respect du temps de parole imparti à chaque oratrice-orateur. Par respect pour chaque oratrice-orateur, je vais devoir me montrer ferme dans ce rôle. De plus, je vous informe que toutes les séances plénières sont vidéo-enregistrées pour la mise ultérieure sur le site du Congrès. En plus, toutes les présentations en plénière sont traduites en 5 langues. Pour conclure ces quelques mots de bienvenue, je tiens à féliciter les organisateurs de ce congrès pour l'initiative de ce projet et pour le travail accompli jusqu'à ce jour. Je pense que l'écho au niveau des participants démontrait bien que ce congrès répond à un besoin. Je vais maintenant passer la parole à M. Bernard Poeton, conseiller en droit de l'enfant à Terre des Hommes, chef de ce projet au sein de cette organisation. Monsieur Poeton, qui, de la naissance de son idée jusqu'à sa réalisation aujourd'hui, a été le moteur de ce congrès, ce qui mérite des applaudissements. Merci beaucoup. S'il vous plaît, monsieur.
Mesdames et messieurs, bonjour. Je vais m'exprimer en français avec un aspect visuel qui sera en anglais. Je me présente, donc je m'appelle Bernard Poeton, je travaille à la Fondation Terre des Hommes et j'ai eu la chance de pouvoir préparer ce congrès en collaboration étroite avec l'Office fédéral de la justice, dirigé par M. Doumermuth, que je tiens publiquement à remercier, ainsi que son équipe, Mesdames Calbert-Mater et Steiger-Lebas, d'avoir contribué à cet établissement d'une horlogerie fine en quoi consiste l'agenda d'un congrès. Et c'est depuis un an et demi que nous avons préparé régulièrement, à travers des réunions, cet agenda. Donc un grand merci à l'Office fédéral de la justice. Ma présentation va être essentiellement pratique, c'est-à-dire que je vous demande d'être particulièrement attentifs aux données logistiques que je vais énumérer devant vous, car cela vous fera gagner du temps dans la compréhension du fonctionnement de ce chronomètre suisse qu'est ce congrès. D'abord, comment avons-nous construit ce congrès, cet agenda? Je dirais, en résumant avec 3 mots qui, à mon avis, résument aussi l'état d'esprit de Terre des Hommes dans ses programmes comme dans la construction de cet agenda: pragmatisme, tolérance et efficacité. Pragmatisme parce que les débats sur la justice juvénile sont en général très émotionnels et l'émotionnel incite au slogan, au raisonnement binaire, alors que vous tous et vous toutes ici savez à quel point, dans le travail quotidien de la justice juvénile, les choses sont extrêmement complexes, elles ne sont pas noir et blanc, elles seraient plutôt en couleurs, de diverses couleurs, toutes les couleurs possibles, et que les solutions ne sont pas magiques, ne sont pas uniques, et qu'il faut pour chaque enfant essayer une solution. Donc le pragmatisme. Deuxième principe la tolérance, c'est-à-dire que, comme le disait le directeur général de Terre des Hommes hier, la diversité des cultures ne devrait pas être d'abord perçue comme un obstacle à l'application des normes internationales. La diversité des cultures peut être un atout, et il y a dans un certain nombre de traditions ou de fonctionnement de ce qu'on appelle la justice coutumière, parfois, il y a des choses qui pourraient être reprises, modifiées, validées, qui permettraient peut-être d'innover, et c'est ce qui sera l'objet aussi des ateliers, d'une partie des ateliers de cet après-midi. En tout cas, comme disait le directeur général aussi, un congrès, c'est une parenthèse professionnelle. Pour une fois, nous nous donnons une semaine pour écouter, pour réfléchir, essayer de comprendre d'autres points de vue. Et c'est l'esprit que nous voulons mettre dans ce congrès. Troisièmement, l'efficacité, bien sûr. L'efficacité, c'est extrêmement difficile de mesurer l'impact des décisions qui sont prises. C'est encore plus difficile de mesurer de manière précise, par exemple, ce qu'est l'impact des méthodes de prévention. Qu'est-ce qu'on a réussi à éviter? Comment est-ce qu'on arrive à faire la prévention de la délinquance? C'est très difficile à mesurer. Mais en tout cas, il faut avoir cette obsession de l'efficacité. Pour construire cet agenda, nous nous sommes posé d'abord la question, quel va en être le concept? Est-ce qu'on fait un agenda ciblé sur les professions en justice juvénile? Une matinée sur la police, une journée sur les assistants sociaux, etc. On n'a pas fait ce choix-là. On aurait pu faire le choix de suivre, par exemple, une procédure judiciaire, l'étape policière, l'étape préventive, de détention préventive, qui est quand même très importante et parfois très grave, l'étape du jugement, l'étape de la réinsertion. On n'a pas fait en termes chronologiques. Le choix que nous avons fait, il est d'étaler sur ces 5 jours le programme suivant sur l'agenda, c'est-à-dire par journée, nous avons décidé dans un premier temps de parler des normes internationales face à la pluralité des systèmes juridiques. Comme vous le savez, dans tous les pays du monde, il y a juxtaposition de systèmes ou de fondements de systèmes juridiques très différents. Comment cela fonctionne-t-il avec les normes internationales? Tous les pays ont le même problème, à des degrés divers. Cet après-midi, nous parlerons de la prévention. La journée de mercredi, la journée de demain mercredi sera essentiellement axée sur le système de justice juvénile, ce qui est bien la question qu'il faut traiter quand on invite les États. Ce sont les États qui mettent au point, qui financent, qui forment le personnel pour le système de justice juvénile. La journée sera essentiellement consacrée au renforcement d'un vrai système, d'un bon système de justice juvénile. Jeudi sera consacré plus généralement aux bonnes pratiques, c'est-à-dire quand on a dit quel était un peu le meilleur système de justice juvénile, quelles sont les bonnes pratiques, quelles sont les leçons apprises, comment pouvons-nous écouter ce que d'autres personnes ou d'autres pays ont essayé, qu'est-ce qui marche, qu'est-ce qui ne marche pas, comment ça fonctionne, quel serait l'idéal, etc. Donc, encore une fois, pragmatisme. Enfin, le dernier jour du congrès portera sur la dimension régionale et internationale, c'est-à-dire que régional veut dire par là que dans certaines régions du monde, il y a déjà une coordination qui fonctionne à des degrés divers et il y a des problématiques, par exemple européennes. Il y a un fonctionnement de coordination régionale en Amérique latine qui est déjà très développé et il y a d'autres régions du monde comme l'Asie qui cherchent désormais à engager un processus de coopération régionale en justice juvénile. Et donc, vendredi, nous aurons des ateliers, mais cette fois, ces ateliers seront régionaux, c'est-à-dire que les représentants des différents pays d'une même région se rencontrent pour échanger sur les manières de coopérer, au sens aussi où on parle beaucoup de la coopération sud-sud, et que finalement, l'aide ne doit pas seulement venir des pays du Nord vers les pays du Sud, il y a aussi beaucoup d'échanges possibles, notamment sur les innovations, les expérimentations. Et il y a des pays dont on ne sait pas, mais qui sont extrêmement créatifs, et ce n'est pas simplement une question de budget, ce n'est pas seulement une question de moyens. Alors voilà, il faut que les pays se rencontrent. Alors, troisième élément, il y aura donc dans ce congrès des sessions plénières. elles sont enregistrées, elles sont filmées, elles seront diffusées sur le site du Congrès un peu ultérieurement. Ce n'est pas en direct et ce ne sera pas une heure après. On n'est pas sur YouTube ici. Hein. Bon. Alors, voilà, donc vous pourrez éventuellement réécouter tel ou tel intervenant sur le site. Les matinées seront composées de présentations thématiques par des experts. Nous commencerons ce matin par les personnes ici présentes. Ensuite, il y aura des présentations par pays. Et je tiens à remercier ici les pays qui, en s'inscrivant, ont accepté d'entrer dans l'agenda. Ce congrès n'est pas un congrès des Nations Unies. Il ne s'agit pas de donner la parole successivement à tous les pays. Il s'agit de demander aux pays, si vous voulez venir au congrès, choisissez le thème sur lequel vous souhaiteriez intervenir. Et la plupart des pays ont accepté ça et je tiens à les en remercier. Autrement dit, d'entrer dans l'agenda. Ensuite, il y aura en fin de matinée, chaque matin, une table ronde, un échange entre experts. Là, ce ne sont plus des pays, ce sont des personnes à qui nous avons demandé de s'exprimer, de donner leur point de vue sur les thèmes qui ont été abordés dans la matinée. Ça se veut aussi une partie un peu plus participative, un peu plus active, notamment en fin de matinée, quand tout le monde attend de pouvoir aller manger. Alors, je signale qu'en plus de cela, vous avez des side events, comme on dit, des événements, des sessions particulières qui ont été demandées par des ONG ou des organismes. Nous aurons, par exemple, demain après-midi, en fin d'après-midi, un side event du CRIN, le Child Rights International Network, qui nous fait le plaisir d'accueillir et d'apporter dans notre congrès M. Sergio Pineiro, le professeur Sergio Pineiro, votre prédécesseur, madame, qui parlera sur la question de la criminalisation des mineurs. Et puis, demain soir, nous aurons aussi une séance de conférence-débat pour les francophones avec les juges, les policiers et les assistants sociaux du canton de Genève. Vous aurez aussi une séance intitulée Kaikaya, c'est-à-dire la présentation d'un système de management, de système de justice juvénile au Nicaragua. C'est un exemple, mais tout ça, vous trouverez sur la table dans la grande salle du hall. Vous trouverez les prospectus qui vous présentent les différents événements qui auront lieu un peu en marge de ces plénières. Il y aura aussi pendant le congrès des rencontres, des réunions privées, private meetings, c'est-à-dire des associations qui ont demandé de profiter de ce congrès pour faire leurs réunions, soit annuelles, soit saisir l'occasion pour faire une réunion de leurs membres. C'est l'Association internationale des juges des mineurs et de la famille, ainsi que la réunion qui a déjà eu lieu hier du panel international en justice juvénile. Photo suivante. Next one, please. Les ateliers. Chaque atelier porte sur un thème. Il y aura 2, 3 ou 4 speakers. Chaque speaker aura un maximum de 20 minutes et 7 diapos de présentation PowerPoint. Nous avons mis cette limite parce que nous avons tous participé à des congrès où très souvent l'agenda a été décalé parce que 2 ou 3 personnes s'étaient exprimées pendant une demi-heure au lieu du quart d'heure prévu, ou ça modifie l'agenda de 800 personnes et ça modifie tout l'agenda et le programme de la journée. Donc, nous serons très stricts et nous avons demandé à tous les modérateurs d'être très stricts sur la gestion du temps de parole. D'autant plus que l'atelier, c'est ça qu'il faut considérer. Je demande aux experts de considérer que l'atelier auquel ils participent, c'est pas simplement leurs 20 minutes d'expression, c'est leur participation aux 2 heures. C'est-à-dire que quand il y a 2 speakers, vous avez 2 fois 20 minutes et il vous reste quand même 1 heure, 20 minutes de débat. Et vous pouvez exprimer dans le débat ce que vous n'avez peut-être pas eu le temps d'exprimer dans votre présentation. Pour chaque atelier, il y aura un modérateur, un secrétaire, une assistante logistique, une technicienne ou un technicien et des interprètes. Donc, on a essayé de faire en sorte que toutes les fonctions soient à votre service et au service du débat et au service des orateurs. Donc, choisissez bien aussi en matière de langue. Quand vous choisissez un atelier, regardez bien dans le programme en quelle langue cet atelier est traduit. Nous n'avons malheureusement pas pu faire la traduction en 5 langues de tous les ateliers de ce congrès. Vous imaginez bien que ça prenait une dimension, notamment budgétaire, qui était extrêmement difficile à assumer. Chaque atelier aura pour but de sortir un rapport d'atelier. Le secrétaire est en charge du rapport de l'atelier qui vise d'abord à énumérer les points qui ont été abordés, éventuellement les points de discussion ou de controverse, formuler 3 à 5 recommandations et surtout que ces recommandations soient accompagnées des modalités de leur application et de leur suivi. Beaucoup de congrès font des recommandations et on repart avec les recommandations. C'est très utile, c'est des références, les recommandations des événements internationaux. On va essayer d'aller un peu plus loin et de formuler, quand on dit une recommandation, on dit aussi qui va faire et quel sera le suivi. Voilà. Diapo suivante. En ce qui concerne la documentation, nous avons ouvert récemment un site qu'on appellera site la plateforme des documents du Congrès. C'est-à-dire que vous avez ici, sous les yeux, le lien en français, le lien en anglais et le lien en espagnol. Vous avez sur ce site les photos, pour les gens qui nous les ont envoyées, les photos des speakers, des experts et un paragraphe biographique et aussi leur présentation et les documents que ces experts recommandent à votre intention. Donc, sur ce site, tous les documents sont classés par thème d'atelier. Vous choisissez un atelier, vous aimeriez savoir quels sont les documents en référence au thème que vous avez choisi, vous allez sur ce site et vous pouvez les télécharger, notamment sur la clé USB que vous avez reçue dans votre sac. Alors, cette clé, d'ailleurs, contient déjà ce qu'on appelle le compendium, c'est-à-dire l'ensemble des documents, les instruments juridiques fondamentaux sur la justice des mineurs, c'est-à-dire en français, en anglais et en espagnol, ce compendium des instruments juridiques universels, internationaux, est déjà dans votre clé USB que vous avez reçue. Donc ce que vous pouvez télécharger, ce sont les documents que vous choisissez sur le site que nous avons ouvert. Par ailleurs, à l'extérieur dans le hall, vous aurez un certain nombre de documents qu'avec les moyens technologiques, il est inutile de faire des centaines de copies pour mettre à votre disposition. En revanche, toutes les copies qui seront dans le hall en bas, vous pouvez les consulter, prendre la référence Internet et retrouver ces documents sur le site du Congrès. Donc il y aura beaucoup de documents qui seront en consultation, au moins dans les 3 langues, parfois en plusieurs autres langues. Je vous demande de les consulter, de prendre les références si ça vous intéresse, mais surtout de les laisser sur la table pour que d'autres puissent en profiter. Et enfin, nous avons une possibilité pour celles et ceux qui le souhaitent, mais ça c'est un choix très libre, d'utiliser ce qu'on appelle les speedy interviews. C'est-à-dire que nous avons une petite salle avec une personne qui est journaliste et qui peut vous filmer pour une interview de 5 à 10 minutes. C'est par exemple si vous avez un point précis que vous n'avez pas pu exprimer ni en plénière ni dans un atelier et vous souhaiteriez que votre point et votre argument et votre conviction personnelle puissent être enregistrés quelque part, sachez que vous avez la possibilité, en vous adressant au stand d'information, de réserver un moment dans cette salle. J'ai presque envie de dire, ça consiste à vous dire choisissez la question à laquelle vous avez envie de répondre et puis vous pouvez, si vous le souhaitez, vous enregistrer. Simplement, sachez que quand ce sera enregistré sur le site, ce sera évidemment public, aussi public que tout ce que l'on trouve sur Internet. Vous pouvez avoir un thème, un sujet qui vous tient à cœur pour une raison ou pour une autre, et vous pouvez vous exprimer là-dessus. Alors adressez-vous au service, au bureau, au stand d'information de Terre des Hommes. En ce qui concerne la logistique, et je termine là-dessus. Ça va, monsieur? C'est bon. Bon, nous allons circuler dans ce centre pendant ces 4 jours qui viennent et je vous demande votre attention pour savoir comment ça fonctionne. Vous êtes ici dans la grande salle qui est comme une sorte de tour et les différentes salles d'atelier sont à 3 niveaux différents, mais les niveaux, les étages entourent la salle dans laquelle vous êtes. C'est-à-dire que quand vous choisissez un atelier, cherchez, regardez d'après les plans à quel étage ça se trouve. Quand vous êtes au bon étage, et vous êtes sûr que vous êtes au bon étage, ça ne peut que tourner autour de notre grande salle. Donc si vous ne trouvez pas, ben, vous retournez dans l'autre sens. Vous voyez ce que je veux dire? Vous ne pouvez pas ne pas trouver parce que, quelque part, vous êtes coincé. Hein? Voilà. Alors, c'est ça un peu le principe, parce que quand on débarque comme ça dans ce centre, qui est magnifique, mais parfois, spontanément, on ne trouve pas. Alors, les salles sont un peu réparties. Regardez l'étage, et sur l'étage, faites le tour. Dans tous les sens, jusqu'à temps que vous trouviez la salle. Vous avez un certain nombre de personnes qui sont des volontaires. Alfonso, est-ce que tu peux te lever, s'il te plaît? Voilà, vous avez des personnes qui sont dans la salle, dans le hall d'entrée, ce sont des personnes qui portent cette veste marron, avec le logo de Terre des Hommes. Ce sont les personnes bénévoles qui sont à votre service pour l'information. Donc n'hésitez pas, ils sont là pour ça, vous cherchez votre atelier, demandez à quelqu'un qui porte cette espèce de petit uniforme avec le logo de Terre des Hommes, ils sont en mesure de vous conduire à votre atelier. Pour ce qui concerne le repas de midi, alors le repas de midi, évidemment, nous sommes très nombreux et nous avons un temps relativement limité. Alors nous avons pris l'option, il fallait bien faire un choix, nous avons pris l'option de ne pas faire de repas qui soit tout le monde assis à des grandes tables avec un service qui est fait pour chacun et chacune. C'est matériellement impossible. Donc vous aurez, à la sortie, à la fin de la session, vous aurez dans le grand hall un certain nombre de sacs. Et vous prenez ces sacs et vous passez, vous aurez un plat chaud, bien entendu. Vous pouvez choisir, mais sachez que c'est une formule de lunch, une formule de repas qui se veut assez rapide et assez circulante, c'est-à-dire que ça permet de ne pas rester assis, de ne pas s'asseoir, de ne pas attendre. Voyez? Donc ça se veut plus pratique. J'espère que cela fonctionnera et que cela vous conviendra. Ici, les personnes qui organisent ce genre de choses ont l'habitude de faire ce genre de choses pour un grand nombre comme vous ici, donc tout normalement devrait bien se passer. Vous avez aussi dans ce centre une salle qui a des ordinateurs que vous pouvez utiliser pour consulter Internet ou pour travailler si vous le souhaitez. Il suffit de demander aux volontaires où se trouve la petite salle. Elle n'est pas très grande, il n'y a pas pour 50 personnes, mais vous pouvez l'utiliser s'il y a besoin. Enfin, pour celles et ceux qui cela intéresse, il y a aussi dans le centre une salle de prière, notamment pour les musulmans qui veulent faire leur prière. Il y a un endroit assez isolé dans le centre. Adressez-vous aux bénévoles si vous souhaitez l'utiliser. Enfin, je voudrais terminer en vous disant quel est le programme d'aujourd'hui. Si j'ai encore 3 minutes, ça va? Le programme d'aujourd'hui, donc nous sommes bien mardi, c'est le jour numéro 2. Le jour numéro 1 était très sympathique hier, j'ai trouvé. Bon. Alors aujourd'hui, donc ce matin, c'est une présentation en séance plénière, vous voyez, sur la colonne de gauche. Donc nous avons des experts qui vont s'exprimer. Ensuite, nous aurons 4 États qui vont s'exprimer aussi, faire une présentation. C'est pas des États, c'est des présentations régionales cette fois. On commence par des gens qui représentent une région et qui parlent au nom d'une région. Afrique, Europe, Amérique latine, Asie. Asie-Pacifique. Ensuite, il y aura une table ronde d'experts. Et ensuite, ce sera le repas. Le repas, c'est de 13h à 14h30. Mais à 14h, il y aura l'inauguration de l'exposition photo, que vous avez peut-être déjà consultée. Donc c'est à 14h, donc juste à la fin de la période du repas, mais cela ne doit pas prendre sur le temps des ateliers qui suivent l'après-midi. On commence par une séance plénière encore l'après-midi sur la prévention. Et ensuite, vous aurez les ateliers. Alors, il y a des types d'ateliers où nous avons pris un thème et nous avons décidé que ce sont des sujets tellement importants qu'il faut le même thème dans un atelier en espagnol, dans un atelier en français, dans un atelier en anglais. Donc, ce sont des ateliers sans traduction, sans interprétation. Donc, chacun peut participer à l'atelier de la langue de son choix. Et enfin, en fin d'après-midi, il y aura aussi un atelier que nous avons fait une exception concernant la participation, le rôle et la place de la police dans le système de justice juvénile. Donc c'est la seule exception que nous avons faite Quand je vous ai dit tout à l'heure que nous avions fait le choix de ne pas traiter l'agenda sous forme, enfin, à travers les professions, nous faisons une exception pour la police. C'est extrêmement important dans la mesure où la police, c'est la première autorité que l'enfant rencontre, en général, dans une procédure judiciaire. Voilà. Et alors, exceptionnellement, l'atelier sur le rôle de la police, il sera interprété dans les 5 langues du Congrès. C'est le seul atelier qui aura les 5 langues. J'invite toutes les personnes et tous les représentants des délégations gouvernementales qui ont une fonction dans la police, au ministère de l'Intérieur, de participer et d'écouter cet atelier où nous avons des experts qui sont extrêmement compétents, qui savent notamment faire des formations en matière de policiers, qui sont des grands formateurs, si je puis dire. Et là, je pense que nos collègues, les policiers qui sont dans cette salle et qui veulent un atelier sur leur profession, le rôle de leur profession, je les invite sincèrement à participer à cet atelier. Voilà en gros ce qui sera l'objet d'aujourd'hui. Donc, je reste à votre disposition, bien sûr, pendant le congrès, s'il y avait besoin de telle ou telle explication. Je pense aux personnes aux délégations, qui ont pas des problèmes, qui ont des questions concernant leur participation dans un atelier ou dans une table ronde. Je suis à leur disposition pour leur réexpliquer peut-être un peu l'esprit. Mais je tiens à redire ici, nous sommes absolument obligés de respecter les horaires. C'est ce que je vais m'empresser de faire maintenant en laissant la parole à la personne suivante. Merci.
Je remercie M. Boeton pour ces informations pertinentes, claires et utiles. Cette journée est donc réservée à 3 thèmes: les normes internationales, la pluralité des systèmes juridiques le matin et la prévention l'après-midi. Il existe à différents niveaux des normes internationales qui régissent également la justice juvénile. Il s'agit de normes qui doivent aider les décideurs et tous les acteurs impliqués à développer les balises éthiques, procédurales et pratiques. C'est donc un must de parler ce matin de ces bases communes de travail. Il va ensuite être intéressant de voir comment ces normes prennent forme dans différents contextes nationaux et quels sont les mécanismes et les orientations propres que connaissent les différentes régions dans ce domaine. J'ai l'honneur d'ouvrir la première séance de ce congrès avec 3 présentations d'experts qui vont nous parler du cadre général de la justice juvénile. Pour commencer, j'ai le grand plaisir de vous présenter Madame Marta Santos Pais du secrétariat général de l'ONU sur la violence envers les enfants. Elle va nous parler de la justice juvénile restauratrice, un modèle souvent cité, un modèle central dans la justice juvénile, un modèle exigeant. Mais qu'entend-on par ce terme et quels sont les principes qui sous-tendent cette définition? S'il vous plaît, Madame.
Merci beaucoup. It's a great pleasure for me to be here, and I would like to start by thanking the government of Switzerland and the Terre des Hommes Foundation for the fascinating congress we are in. And I think after having seen yesterday's opening session and having listened to the wonderful roadmap that Bernard Breton has shared with us, no one will ever wish to go out of this wonderful building. So I'm really thrilled to be able to join you here. This Congress is going to put a finger on many of the challenges that confront the life of children in all countries around the world. But I think it's very important also to feel that the Congress is taking place when we have so many auspicious initiatives taking place. That gives us a hope that with the Congress and what is happening outside of the Congress, there is a way of changing the pattern of stigmatization, criminalization, and hopelessness that affect the life of so many children and adolescents around the world. And I would like to recall some of those auspicious, promising developments. The first one is certainly everything we have recalled and have wished to build upon when last year we were celebrating in so many parts of the world the 25th anniversary of the Convention on the Rights of the Child, where we had the opportunity of reflecting on the many things that have changed the perception of childhood, have forced governments and institutions to look at children in a different way, as partners in development, as agents of change, and not simply the silent human beings who are there to be told and follow whatever adults feel is right for them. Secondly, as you know, during the General Assembly in the fall, we saw the adoption of a new important document, the United Nations Model Strategies and Practical Measures to Eliminate All Forms of Violence Against Children in the Criminal Justice System. And in this regard, I know that many will talk about it, but I would encourage you to look into this important new set of standards. And in this regard, just to mention that thanks to the Attorney General of Thailand, there is a notebook available which will remind us of some of the elements that are in this important new document. And thirdly, and not less importantly, the General Assembly has also, when reflecting on the anniversary of the Convention on the Rights of the Child, decided to call for a global study on children deprived of liberty, recognizing that, in fact, in most countries of the world, we are still confronted with the lack of information about how many children are behind bars, for which reasons, for how long, how much they are benefiting from the safeguards that they are entitled to in the light of the important standards adopted by the international community. So we have these promising developments that, again, give us hope. And part of, throughout, as a cross-cutting theme in all these developments, we have the recognition of the importance of restorative justice as an alternative to the traditional stigmatization and criminalization of young people who are perceived as having done something wrong and who are often called as being in conflict with the law, when at the same time, in so many situations, have no conflict at all with the law. They just happen to be on the streets, they happen to have fled home because they were subject to violence and abuse, or because they are girls, they are victims in rings of prostitution, they are considered to be of immoral character, and as a response, society feels that they need to be subject to the criminal justice system and very often deprived of liberty. So restorative justice opens a paradigm, a new paradigm, to think about what the justice system is about, how safeguards for children can be implemented, and how we can envisage children either when they are allegedly offenders of the criminal law or they are victims or witnesses in a different pattern, through a different universe. What we feel also is that restorative justice in a way responds to the very important values that are cherished by all societies of what fairness and justice are about, and open a new opportunity to achieve this goal. For this reason, we have been working with many friends and partners within the United Nations at the regional level, at the national level, and many of them are here in this room, in promoting an important report on restorative justice for children that I would encourage you to look into. We have copies to share with you for those who would have an interest. And I wanted to recall what this report brings. And perhaps the most important thing is that it tries to respond to what children tell us so often, and certainly tell me in all the trips I do around the world. Many of them tell me it's very sad that we are considered to be people with no value for society, but worse than that, people who have no values whatsoever. But still we are children, just like any other child. And recently, I was in an important congress in Latin America, and the children who were there were very vocal in addressing what juvenile justice should be about and what kind of justice should be offered to children. And they were emphasizing two important messages that I really keep reflecting upon and I think will be important for the Congress. One is the concern that fear is the word that defines their daily life. You know, fear of being harassed in the street, of being victims of extortion, of being induced to join gangs who are seduced or forced to commit criminal activities, or end up being behind bars because they are poor and they just stole a loaf to survive. But also the other message was how much young people look for a world where there is security and there is justice. You know, security to grow up with confidence, to play in the streets without fearing any attack of anyone or being considered a danger for society because there are too many young people together in front of a public space, which is happening in so many places around the world. And justice to be able to safeguard the rights of children, a system of justice that children understand, that children trust, and a system that is ready to take into account the frustrations and expectations of young people, even when they are allegedly responsible for having infringed the criminal legislation in force in a country. So, in brackets, let us not forget that all of this is a reflection that is taking place when the international community is shaping a new development agenda for beyond 2015 that in fact aims at two important topics for our discussion now. One, the elimination of all forms of violence, abuse and exploitation against children, and secondly, the development of transparent, strong and accountable justice mechanisms and institutions ready again to safeguard the rights of everyone, including children. So, restorative justice is important, and it's important before anything because it opens the door for a system that is effective in ensuring the right of children to access justice. To access justice, understanding what the process is about, having the right information, feeling empowered, advised, counseled and supported to obtain the solutions through the system that in fact satisfies not only the child but the family and the community. And this is very important when children are at risk of stigmatization and criminalization, as I have mentioned a moment ago. So the restorative justice system, in a way, calls for solutions that are non-punitive, that are addressing the causes and the consequences of offending, and are, rather than focusing on punishment, are trying to repair the harm that may have been caused by some wrongdoing by young people. This is becoming a very important concept. I know that many countries represented here are putting it in place, and certainly we want to learn from your own experiences of implementation. But in a way, it's important to recall that this is a system that has been present in many parts of the world for many decades and centuries as a way of solving conflicts and also promoting conciliation and overcoming tensions arising from conflicts that happen within the community or within the family. So what are the key dimensions, the key principles affecting restorative justice? Well, the first thing that is important to stress is that restorative justice for children is by definition inclusive and participatory. It means that it brings together the offender, the victim, the community, child protection and justice professionals, and all of these actors join hands in trying to find a solution that is acceptable for everyone, and at the same time express a commitment to make sure that the solution agreed upon is going to prevail, is going to be respected by everyone. So it engages people, it brings commitment into a strong level. Secondly, it's non-adversarial as a process. It's based on dialogue, on negotiation, on solving problems that affect people. And for that reason, it's also a voluntary process. It's a process that the offender, the victim, the community adhere to because they feel there is a hope that we will find a solution that serves us all and is not only simply imposed by a judicial entity, even if I don't understand very well what the decision is about. This decision, this voluntary process, recognizes the harm that has been imposed. It also recognizes the accountability for the wrongdoing. So it is not intended to erase responsibility or to give a sense that whatever wrong we provoke is going to go unnoticed and nothing is going to happen. I'm irresponsible for that. No, it's purposeful and it is intended to give a sense, again, of fairness and justice in society. The third dimension that is important is that it is adaptable. It can be promoted through different solutions. And there are a number of solutions, of course, that have been tried out around the world. Mediation, conciliation, conferencing and sentencing circles are some of these models, and I'm sure many of you are engaged with them. And they promote healing and they promote respect. Again, people listen to the views of each one. We understand why a young person did something that we perceive as very wrong, and perhaps there are reasons for it, and at the same time, those who do something wrong understand the impact it has provoked on others. It therefore can be used and is of relevance for the child who is an offender, a victim, or a witness, and it can be introduced at all stages of the criminal justice process. And very often it is associated with services that can, again, give an answer, promote a reintegration that is genuine and effective for the child who has been engaged or who is an offender of the criminal law. What is very interesting is that when we study the experiences around the world, we see how much people recognize the benefits of restorative justice processes and programs. First, because it is a participatory process, people feel that they were so engaged in finding the solution that they feel responsible for ensuring compliance with the agreement that has been reached. In some countries, this compliance reaches the level of 90%. So it's not something distant to people. It is something that tells a lot to those concerned. Secondly, children, in fact, who are involved in these processes are much less attracted to antisocial behavior. There is lower levels of recidivism. We see that the young person who has committed an offense is in fact much more committed not to go back into a situation that can drive to the commission of another offense, but rather wants to be a constructive actor in society and supporting the reparation of the harm he or she may have caused. Restorative justice also helps to reduce and prevent situations of deprivation of liberty. And another dimension that we felt interesting was that parents and families of young people who are engaged in restorative justice process also find themselves much less tempted to use violent discipline forms to handle their young people who they may feel may be difficult. You know, they find alternatives to violent reactions and solutions. As I said earlier, there is also a greater sense of fairness and justice in society. Offenders feel treated with respect. They believe that there is less stigma and humiliation. They can explain why they did something that was felt to be wrong, and also to explain that they want to do something to repair the harm. But the victims also feel more respected. They feel that they have the time to express how much they felt hurt or how much was destroyed in their lives. They can pose questions to the offender. They feel that there is this dialogue that in a way brings people closely together rather than each one going his or her own way, you know, looking at the enemy rather than someone who wants to really present an apology, being forgiven, feeling repentance, and looking ahead with a constructive attitude in life. The other part that is not less important in a world that is so affected by economic recession and difficulties is that restorative justice reduces the costs of justice. It certainly reduces the cost of judicial proceedings, of keeping a young person behind bars, and no doubt it reduces the costs, the personal cost of those who are involved with the justice system. To use one estimate, a study that was conducted, the cost of losing a single youth to a lifelong cycle of crime and drug abuse may be between 1.7 and 2.3 million US dollars. That's the kind of value that we can reduce and use to prevent crime and use to prevent stigmatization and deprivation of liberty of young people. So young people engaged with restorative justice are much more open to go back to school, to engage in vocational training, to participate in community programs, and to be active members of society. So there are so many good things we can learn, and we drew a number of recommendations that very briefly I wanted to share with you. Certainly the first recommendation we saw is the importance of legislation. There are, I'm sure, many lawyers here, and we always believe the law is important to set the clear message for society of what is right and what is not acceptable in our nations. And it is very important to understand that one part of that legislative process is to understand how much what we have in our countries may be in conformity with international standards or may be not in conformity with those standards. And this may be the national legislation, but it may also be the customary or religious laws that are in practice in our countries. We need to make a comprehensive review and to align them all together. And interestingly, when we were looking at many experiences, we saw countries like Indonesia, and I know we have some friends from Indonesia here, who were very committed to having, first of all, a strong piece of legislation who could guide the country in the best use of the restorative justice promising processes. You know, engaging in capacity building of the professionals, making everybody aware of what this is about, how it can work best. Legislation was an important starting point. And then we have countries like Peru also present here, with very good actors in restorative justice present here, who thought, well, before we have the law, perhaps we need to see how the process works best. And there were a number of piloting experiences from which the country drew conclusions that are now informing a new piece of legislation that we hope will be adopted soon on the Code on the Rights of Children in Peru. So we can go different ways, but it's important. Legislation is always an important dimension of it. Legislation certainly also helps to decriminalize survival behaviors and status offenses that in so many countries are still leading so many young people behind bars, being deprived of liberty, stigmatized, and considered to be of no value and without values, as I mentioned earlier. Legislation is also fundamental to include diversion measures that the actors in the justice system can make use of. And if it is not clear what this is about, the temptation may be to just forget it. Of course, legislation should clearly recognize that deprivation of liberty is a measure of last resort and only for the shortest period of time, and all the possible options before deprivation of liberty need to be very clear. And this needs to work in formal and informal justice systems. No doubt there will be more discussions about it. The second important recommendation we drew is how fundamental it is to invest in the capacity building, in the training of all the actors who can make a difference in this process. And of course we need to know about what the legislation is about, what child rights principles, proceedings are about. But when we deal with restorative justice, we need to engage in gaining skills on dialogue, on managing conflict and tensions, and bringing people together around a circle where people listen to each other, generally interested in finding a solution that is relevant for all. That is not necessarily easy. So, you know, mediators will be important, the community supporters will be important, the volunteers will be important to gain these skills. The third recommendation is the importance of promoting coordination between the different sectors. As we know, justice is not simply one little group. It needs to cooperate very closely with education, with social protection, with health. There are so many areas that make a difference in preventing criminalization and ensuring reintegration of young people. Without that, we will not go far. And this needs to be supported naturally by sound data, by good studies and evaluation of what works best and what is the impact it has on people in the country. Without resources, we will not go far, certainly also. The last recommendation I wanted to emphasize with you is the importance of awareness raising and mobilization initiatives that affect so many people. In some countries, affect the judiciary and the justice actors, first of all, who feel a bit tempted to go back to the traditional code just more than giving restorative justice an option to make a difference, but also how the public accepts it and engages with it and supports it in any possible situation. Of course, I remain very committed to moving forward this process and look forward to collaborating with you. And I want to end with two things. Firstly, just a month ago in Brazil, we had a Pan-American Congress of all states of the whole continent of the Americas, bringing together governments but also young people, and the young people had a reflection about what juvenile justice is about, and they made a number of recommendations that I feel are so fundamental for us. For instance, they call on all members of the Organization of American States to make sure that 18 is the minimum age for any penal sanction that is associated with deprivation of liberty, and any other below this age alternatives should be explored, including restorative justice measures, who should be invested in systematically. They recognize the need to be always treated as subject of rights, and they were explaining what this is about, and certainly not being ignored in the justice system is one. They call on the media to promote restorative justice processes and programs, to make them known as an option, rather than only reporting on punitive measures and a sentiment of revenge and social pressure that ends up bringing pressure on governments to be tough on crime and to make children pay the price. They recognize the importance of preventing the stigmatization and deprivation of liberty of children who live and work in the streets. And they, of course, emphasize the importance of investing in prevention and effective and genuine social reintegration for all children. These seem so easy to implement, these recommendations that young people anticipated, and yet seem so distant of the reality most children endure around the world when involved with the criminal justice system. I finally wanted to end with a little video that we would like to share with you, just to illustrate what restorative justice can bring as a promising solution. Thank you so much again.
In this video, you will hear about different situations that other young people have been in and how a family group conference has helped them.
It's where you, your family and your social worker can get round the table and decide what's great for you in your life.
I would say it's not a normal meeting. Like, they weren't only talking about me, they was talking about my brother and my dad. We all had the same issues and stuff.
For the family conference, I got 3 of my aunties, my nan, 2 of my cousins, my mum, my little sisters, my mum's friend.
I met my social worker, he said I should do family conference, and I just went in there and do what I had to do. I brought my mum and my dad and my brothers.
So the meeting was different because I had my family there with me to support me.
So why did you have a family group conference, do you think?
Because I was on the child protection plan, and it would help our family quite a lot to have what's good for us.
We sat down as a family and we just discussed about like particular subjects, like me being misbehaving, things like that. It just like helped me think about what I should do and what I shouldn't do.
I had a chance to say what I wanted as well at the meeting. I said that I want to move house so I can get my own bedroom, and my mum's trying to get another house now. And I said I still want to have contact with my dad.
Our plan was to build my attendance up and punctuality at school, same with my brother.
It was just like a nice, peaceful, private meeting in a nice, peaceful room.
Well, the food It made me happy. I just looked at the food and I was just listening and eating.
It felt like, yeah, I've got listened to, and I had my own say as well.
This is Zach's story.
I used to hang around the estate with my friends and have a laugh. People complained to my mum saying that was a menace. This really stressed her out, but she really had a lot to cope with. And things weren't going so well at school either. So, my mum wasn't happy. The residents on the estate wanted us evicted, and I was about to get chucked out of school. The welfare officer at school has suggested an FGC. I thought I might as well try it. He said that me and my family would be in charge of making the decisions. My mum, auntie, plus some local residents and my teacher came along, as well as the school welfare officer. In the first part, we discussed the situation, all putting our points of view across. Some older people from the estate said they felt really intimidated by me and my friends, and it was making it hard for them to go out. I hadn't realised how bad it was, and I felt really sorry. Then, Mum and I talked about everything that was stressing us out. It felt good because people seemed to care about us. Then all the workers and residents left the room, so it was just me, my mum and my auntie, and we came up with ideas about how to make things better. I decided I wanted to do some voluntary work on the estate to earn some respect and show I really was sorry. We talked about things that would help me get on better at school, like having some extra help with the things I found hard, because I want to get an apprenticeship when I leave, and going to a football club so I don't always hang around with the same people. The residents liked the idea, and they even suggested getting other residents together to help my mum out with some shopping and things. I'm glad I had the FGC. My mum and I are getting on better now. And I like doing work on the estate. I'm pleased the residents aren't scared of me anymore. I don't find school that easy, but I'm making more of an effort now, because I want to make something of myself.
Since I had the family group conference, I feel different, like, I feel more mature, like, responsible for myself, like, not all the time my family's there for me. Or, they are there for me, but, like, sometimes I have to do things myself. I've got the same friends, but they've changed. They've thought about their life as well, so.
After the meeting, I felt very relieved. It helped us to realise that we should all put in together, take out a part each, for us to make sure that I'm safe and okay and everything's going well.
If I haven't had the family group conference, me not going to school would have probably still happened, and same with my brother and my dad wouldn't have got support and help.
Yeah, I'm pleased I had the meeting because things have changed and it's better.
I'm very thankful that we had the FGC meeting because it's helped out our family a lot.
If you're thinking about like having a family group conference, you should have one because it's not that scary. It's alright.
FGCs can work in many different situations. If you want to find out more, go to our website or contact the worker who suggested it.
Je remercie Madame Sanders-Pais pour ses explications claires. Mesdames, Messieurs, permettez-moi encore une fois de vous prier de respecter le temps. Je crois que c'est très important. Si nous voulons que ce congrès sera un succès, tout le monde a la même chance de s'exprimer. Je crois que c'est vraiment un point crucial. Comme deuxième intervenante ce matin, j'ai le grand plaisir de donner la parole à Madame Anne Grandjean du bureau régional de l'UNICEF pour l'Europe et l'Asie centrale. Madame Grandjean va nous parler de l'approche droit de l'enfant dans le domaine de la justice juvénile. S'il vous plaît, Madame.
Thank you. Excellencies, distinguished delegates, ladies and gentlemen, dear friends, good morning.
On UNICEF's behalf, I want to start by thanking the government of Switzerland and Terre des Hommes for taking the important and timely initiative of this first World Congress on Juvenile Justice, and for also giving us the floor to speak about the spirit and principles of a rights-based approach to juvenile justice. The starting point for this approach is the fact that before being in conflict with the law, children in justice processes are children first. And because they are children, they have the same rights as all the other children. And because they have rights, we, all of us, government, civil society, international organizations, professionals, we all have the obligation and the responsibility to make these rights a reality. And this is precisely why we all here this week. It is this obligation to children and our commitment and responsibility to meet this obligation that made so many of us come to Geneva this week. So to set the stage for the many discussions to come this week, I've been asked to highlight some of the key principles that define a rights-based approach to juvenile justice. All of these principles, they're grounded in the very rich international legal framework that we all know about and that has been mentioned already several times yesterday, the Convention on the Right of the Child, the CRC, the Riyadh Guidelines, the Beijing Rules, the Havana Rules, to name only the main ones. So what is a rights-based approach to juvenile justice? In other words, what is a juvenile justice policy that is respectful of child rights? First, such a policy should aim at the reintegration of the child. And all of the juvenile justice interventions, from the very first contact with law enforcement all the way up to the implementation of the measure and aftercare, have to be crafted around that objective of reintegration, meaning the fact that the child would go back to his or her community and not reoffend, and go on with his or her life. Obviously, children are still in the process of developing, both psychologically and physically, and when they break the law, they are therefore to be considered as having a lesser culpability than adults. And for this reason, because of this particular developmental status, the traditional objective of criminal justice, retribution or repression, give way to reintegration in the case of children. After entering the justice system, the child continues to have a right to full and harmonious development, which is one of the guiding principles of the CRC. And the juvenile justice system, together with the child protection system and other systems of the state, should continue to realize these rights and to prepare the child to go back to get ready for life in society. So to adapt to the different developmental stages of children and to fulfill this objective of reintegration, the juvenile justice system, as we know, has to be specialized. It needs specialized procedures that are adapted to the age and maturity of children, and specialized professionals who know about child rights, understand the different needs of children, are able to communicate with them and to make decisions in their best interest. As we know, however, reality is quite different, and most juvenile justice systems are not fully rehabilitative yet, and many of them are still very repressive. And this is probably one of the reasons why reoffending is so common, which shows that the objective of reintegration has not been fully met. Second, a juvenile justice policy respectful of child rights provides each child with a tailored and supportive response. So, as we know, all children have the same rights, but not all children have the same needs. So, for many children who have committed an offense, a very light response, such as a warning, for example, will be sufficient for the child not to reoffend. It's actually a normal state of adolescence to be testing the limits. And for many children, just being warned will be sufficient to go back to a normal life. But for many other children, they will need a much more in-depth and intense type of support such as substance abuse treatment or mental health services, to name only these examples. In reality, as we know, however, the children who have committed very minor offenses often get heavy and disproportionate sentences. I encourage you, for example, to listen to the story of a boy from Ukraine that he says in one of the videos that we are showing in the corridors, a movie that he did himself to tell the story of how after stealing one cell phone he got 4 years of imprisonment. So on the one hand, disproportionate sentences for minor offenses, and on the other hand, some of the children who need the in-depth support that I mentioned before do not receive it and then go back to the exact same situation that had led to offending. So to respond to the various needs, to the different needs, there should be a range of different services that respond to these various needs: counseling, probation, substance abuse treatment, community services, educational and training program, and many more, of course. The quality of these services is actually very crucial, and it's still a gap in many systems. It's actually the quality of this support that will determine the success of the intervention, and that will determine whether the child is fully reintegrated or not. And in this respect, I wanted to quickly highlight the role of social work that, to my sense, is really of the essence. And as also Marta said before, juvenile justice is not only about the justice system, but it's also about social protection, social work, the role of education, the role of health. It's not only a justice issue, but it's clearly a very cross-sectoral issue. In order to be able to provide the response adapted to every child, a professional should be able to assess the various needs and to make decisions in line with the child's best interest. And again, this is one of the guiding principles of the CRC. Weighing the different interests and circumstances at stake, professional should be able to determine what is the best interest of that particular child in front of them at that particular moment, and to decide accordingly. And securing the best interest of the child throughout the process should be a primary consideration guiding all decisions. Third, a juvenile justice policy in line with child rights should not discriminate. And non-discrimination, as you know, is a third guiding principle of the CRC. So as I'm sure you all experience in your daily practice, conflict with the law is very often a consequence of poverty and exclusion. And everywhere in the world, children from lower income backgrounds or from minority groups are overrepresented in juvenile justice system and in detention in particular. This is not because they offend more, but this is because they're more likely to be arrested if they do. They won't be able to pay the fine, they won't be able to pay a lawyer, and sometimes the bribe. Many of these children who enter the juvenile justice system also have been already failed by adults and the states. They've been excluded from schools, they fell through the crack of the social protection system, they've been deprived of parental care, victims of violence, and so on. Many are also engaged in survival behaviors like vagrancy or prostitution, or have committed status offenses, which, as you know, are offenses that are considered as such only when committed by children, such as drinking alcohol, being beyond parental control, truancy, and so on. So the point is that the vast majority of these children are actually not a threat to society. And all these situations should normally be dealt with by child protection measures, including effective support to the family or the other caregivers, and measures to address the root cause of this behavior. Without this, the interventions often bring a repressive response where the solution would actually be of a social nature. Fourth, juvenile justice policy respectful of child rights uses detention in exceptional circumstances only. As mentioned in the juvenile justice system, children in juvenile justice system have the same rights as all the other children. But actually we've noticed with the many years of practice that it's actually very difficult, and some would argue even impossible, to realize all rights of children when they are in detention. As we know, violations are extremely common. Violence is also very prevalent. It happens behind closed doors, out of sight from family and the general public, with only very little opportunities for children to complain and to seek help. And as we know as well, experiencing violence can lead to more violent behavior, which is one of the reasons why prisons are often called the university of crime. Also, stigmatization, isolation from support networks such as family and friends, and desocialization resulting from detention jeopardize even more the possibility for the child to reintegrate, and possibly creates even further problems for the future. So actually detention often pushes children even deeper into exclusion and poverty. Detention also doesn't solve the causes of the problem, and as I mentioned before, upon release, the child often goes back to the very situation that led to the offending, and therefore very often does reoffend. So for this reason, detention should be used as a very last resort only, and the benching rule has clearly established that imprisonment should not be imposed unless there are three conditions in play. One condition is that the child has committed a serious act involving violence against another person, or that the child persists in committing other serious offenses, and that there should not be other solution. So as we see these criteria as very strict, but they're also not very much respected. And out of the 1 million plus children in detention worldwide, for the majority of them, this last resort principle was not fully respected. Fifth and lastly, juvenile justice policy respectful of child rights should consider children as actors and resources in problem solving. The measures that have proven the most successful in ensuring the child reintegration are those that, in addition to responding to the particular needs of the particular child, as I mentioned before, also consider the child as an active actor in solving the problem that was created by the offense. And measures that work tend to provide for the following elements that are on the screen. The child accepts responsibility for the act. The child understands the consequences for the victim. The child provides reparation wherever possible. The child receives guidance and supervision to prevent reoffending. And both the victims and community see that justice is being done. These elements are usually found in restorative justice approaches that have gained much attention in the recent years, and I won't detail any of these because Marta has already covered it extensively. But I just wanted to highlight this so as to make it really clear that the right response is not about not responding at all to the offense, or is not about being lenient, but it's just about selecting the right response for that particular child and respect his or her right. So we have reviewed some of the key principles of a rights-based approach to juvenile justice. It aims at the reintegration of the child. It provides each child with a tailored and supportive response. It does not discriminate. It uses detention in exceptional circumstances only, and it considers children as actors and resources in problem solving. Now, the good news is that, in addition, this approach is also, one, an efficient way to prevent reoffending and secure public safety, and two, is also a lesser burden for government's budget in the long run. In terms of public safety, there is evidence that juveniles who have been diverted tend to reoffend less than those who have been prosecuted. And there are two very interesting recent meta-analyses, one that was carried out in Canada in 2013 and an American one carried out in 2010, that both concluded, after reviewing tens of evaluations, that the rate of offending by juveniles diverted was, on average, respectively 8% lower in one of the study and 5 to 6% lower in the other than for children than reoffending for juveniles who had been prosecuted. The Canadian study even found that this was true for repeat offenders as well. So it's clear that by working towards social inclusion rather than exclusion, a child rights-based approach contributes positively to national security agendas as well. In terms of cost, also evidence shows that investment in prevention, diversion, and alternatives is more cost-effective in the long term. Even if diversion and alternative program results in additional initial setup costs, these are usually then compensated in the medium term. In any case, these costs are far less than building new detention facilities. The running costs for diversion and alternatives are much lower than running costs of detention facilities, and also reducing the number of minor and less serious offenses clogging up the formal justice system allows resources to be focused on repeat and high-risk offenders. So, although detention is sometimes seen by government as an easy fix with immediate political gains, it's actually working against all interests, against the interest of the child, of the community, and of the states. And on the other hand, a child rights approach to juvenile justice makes sense from all possible angles. This is my last slide. Just a few words on the way forward. There would obviously be much to say that I will not have time to develop, and that will in any case be the topic of discussions in the coming days. But I wanted to highlight two issues. First, to reiterate that the child rights approach implies that no child, including the most vulnerable, is left out. And this means that our responsibility and accountability to children will not be fulfilled until the most vulnerable among them is taken into account. And second, I also wanted to say that our agenda for the coming years should be broadened to all the other children who are extremely numerous, who are also taking part in justice processes for other reasons, not because they have offended, but because they are victims or witnesses of crimes, or because they're taking part in civil and administrative proceedings like divorce, custody, care, paternity, identity processes. And the rights of these children are also very much neglected so far. And by extension, I would say also that our agenda needs to expand to access to justice in general and make sure that all children who have their right violated or their entitlement denied, education, health, social benefits, and so on, have the opportunity to claim redress when these rights have been violated. There's been extensive discussions globally on access to justice for adults generally, but children are not well taken into account in these agendas. And placing them on these agendas should be one of the priority to our sense. Because it's only when all children will have access to justice that the notion of child rights will find its true meaning. Thank you for your attention.
Je remercie Madame Grandjean pour ses considérations intéressantes et importantes sur les droits de l'enfant. C'est avec grand intérêt que nous allons maintenant entendre Madame Alexandra Martens du Bureau de prévention du crime justice pour enfants de l'Office des Nations Unies contre la drogue et le crime. Elle va nous parler de la question comment la justice juvénile peut-elle être un facteur de développement dans le contexte de la réforme globale de la justice. S'il vous plaît, madame.
Merci. Excellencies, distinguished delegates, ladies and gentlemen, dear colleagues. First of all, on behalf of UNODC, I I would like to thank the government of Switzerland and colleagues from Terre des Hommes Foundation for having organized the first World Congress on Juvenile Justice, which will certainly contribute to raise the profile of such an important thematic area. I would also like to express gratitude on behalf of UNODC for having associated us with this event and for having given us the opportunity to talk about a very important topic, which is the place of juvenile justice in global justice reform and for a development perspective. It is certainly not an easy topic, and I will try to use the few minutes I have to touch upon three main issues. First of all, I would like to outline some of the key challenges faced by many countries all over the world in the area of juvenile justice. Secondly, I would like to briefly mention what are the linkages between development and justice reform. And finally, I would like to talk a bit about the approach that should be adopted for juvenile justice reforms to be effective and sustainable. Please allow me to begin my presentation by referring to the mandate and work of UNODC in the area of juvenile justice. So for those who are not familiar with the United Nations Office on Drugs and Crime, we are an office, part of the Secretariat of the United Nations, and we have the mandate given by many resolutions from the General Assembly and Economic and Social Council to support member states in strengthening justice systems, and in particular juvenile justice systems. So UNODC assists countries in ensuring that children are better served and protected by justice systems when they are in contact with the law as alleged offenders, victims, or witnesses of crime. So the work of UNODC in the area of juvenile justice is based on three mutually reinforcing pillars. The first one is data collection, research, and analysis. The second one is our normative work, and the third one is our technical assistance work. With regard to the normative work, UNODC serves as the secretariat to a policy-making body of the United Nations, which is subsidiary to the General Assembly, and that is the Commission on Crime Prevention and Criminal Justice. And we also serve as the secretariat to the United Nations Congress on Crime Prevention and Criminal Justice, which takes place every 5 years, and the next one is happening in Qatar in April this year. In this function, UNODC assists member states in the development of the international legal framework in the area of juvenile justice. So our office has supported member states in the development of all of them, including the Beijing Rule, the Vienna Guidelines, the Riyadh Guidelines. And as Marta mentioned before, there is a recent normative instrument that is related to juvenile justice, which is the United Nations Model Strategies and Practical Measures on the Elimination of Violence Against Children in the field of crime prevention and criminal justice. This set of new standards and norms was developed last year and adopted by the General Assembly last December, thanks to the key role played by the governments of Thailand and Austria. This instrument was developed in close cooperation with key UN partners, in particular the Special Representative of the Secretary General on Violence Against Children, Ms. Marta Santos Pais, UNICEF, OHCHR, as well as with key civil society organizations. And it is a very important benchmark for preventing and responding to violence against children when it happens when children are in contact with the justice system. I would like to take this opportunity to thank our partners, the Office of the Attorney General of Thailand and the Thailand Institute of Justice, for joining hands with UNODC in the promotion and dissemination of this new tool, and I would like to invite all of you to take a look at this instrument. So when it comes to the operational work, UNODC provides technical assistance to countries to help them to promote juvenile justice reforms. And the more we support countries in their efforts, the more we realize that the challenges they face are pretty much common. I would like to take this opportunity to mention some of them. So the first one that comes to mind is the lack of governmental commitment to fulfilling the rights of the child in the administration of justice. So frequently, adequate budgets and policies are absent, and as a result, institutions and professionals dealing with children are insufficiently equipped with regard to human and financial resources. Lack of governmental commitment is sometimes also reflected on inadequate legislation and enforcement. National legislation in many countries are not in compliance with the international legal framework, and where it is in compliance, very often it is not properly enforced. We also see, as a common challenge, the lack of specialized institutions and lack of capacity of professionals dealing with children in contact with the justice system. Frequently, children in contact with the law end up being dealt with by the ordinary criminal justice system that does not provide for mechanisms and procedures which enable these children to benefit from child-friendly measures. It is also a worrying trend that way too often punitive approaches for children in contact with the justice system are applied rather than restorative approaches. And this leads to an increase in the number of children who are being drawn into the justice system. If we assess, many times we do that at country level, the profile of these children, we realize that many of them are actually in need of care and protection and should not be dealt with by the justice system, as it often happens. There is also a worrying trend to deprive children of their liberty and a lack of application of alternative measures to judicial proceedings, what we call diversion, and alternative measures to detention. Very often we hear from judges that they prefer not to apply alternative measures because of the social pressure they feel that by not institutionalizing a child, they are not providing society with an effective response. Also, very often, we see the lack of mechanisms, institutions, and procedures to apply or to effectively supervise the application of alternative measures to detention. And we cannot avoid mentioning that in many countries, conditions of detention and the treatment of children who are deprived of their liberty are inhumane and not at all conducive to their rehabilitation and social reintegration. Another common challenge in most countries all over the world is the lack of coordination amongst institutions and actors within the juvenile justice system. It's not surprising to hear from prosecutors that they do not cooperate well with the police, to hear from judges that they are not able to establish effective working relationship with child protection actors, and that is why they do not apply alternative measures to detention. Another problem that we should not underestimate is the increasing number of children who are in contact with the justice system and end up being victims of violence, and those who are in the system and at risk of becoming victims of violence. Very often, children and their families lack the skills and knowledge to exercise their rights, and they do not have the conditions to participate effectively in the juvenile justice process. We all know that the community and the family of the child play a critical role in the protection of the child who is in contact with the justice system. That is why ensuring the involvement of families and communities in the juvenile justice process is essential to support positive changes, such as diversion, alternative measures, and restorative justice processes. And the same applies to the engagement of the media and civil society in promoting open discussion and positive change. But what we often see, however, is the engagement of media to demonize children who are involved in crime, and to support, in many countries, the worrying trend to reduce the minimum age of accountability. And very often the media alarm on increasing number of crimes committed by children is not backed up by data and statistics, but it has proven to be extremely effective in the adoption of more punitive approaches. Finally, the last challenge I would like to mention is the lack of data and statistics on crimes committed by and against children, and on the performance of the justice system in dealing with children who are alleged offenders, victims, or witnesses of crime. This will, of course, lead to the development of policies and programs that are not evidence-based and that are likely to be ineffective. This also leads to the inability to measure progress of interventions. So, we have to recognize that despite all the progress achieved by many countries in promoting the rights of the child in the administration of justice, 25 years after the adoption of the Convention on the Rights of the Child, a lot more needs to be done. And this is certainly a very important forum to discuss what needs to be changed and how we can join hands to overcome all the challenges and to promote effective juvenile justice reform. Let me now try briefly to contextualize the topic juvenile justice in the global justice reform and from a development perspective. So the question to ask is, what are the linkages between justice reform and development? And I think that we all know that it has been extensively acknowledged by the international community that fair, effective, and humane justice systems are a pre-requirement for the achievement of sustainable development and represent an enabling condition for upholding the rule of law. We all know that unfair, ineffective justice systems are an obstacle to the achievement of sustainable development. They weaken the rule of law, lead to human rights abuses, and foster inequality. It is also a well-known fact that weak justice systems suppress economic growth and hamper financial investment, which has a direct impact on the quality of people's life and encourages corruption, organized crime, and insecurity. Injustice fuels social discontent and triggers social unrest and violence. On the other hand, functioning and accessible justice systems with accountable and responsive justice institutions can certainly serve as the main avenues to claim for rights and overcome social deprivation, exclusion, and denial of entitlements. Accountable and inclusive justice institutions contribute to equity and poverty alleviation, protect the socially weak, and promote the distribution of opportunity in society. It is indeed a great achievement that the international community has recognized the strong linkage between justice and development, and placed this issue very high on the international development and justice reform agendas. As most of you know, the international community is currently developing the post-2015 development agenda, and in August 2014, the Open Working Group of the General Assembly on Sustainable Development Goals presented its report before the General Assembly, and it contains 17 goals, which includes Sustainable Development Goal 16, which is to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. So, in a context where the linkages between justice reform and development have been well established, it is imperative to stress also the need for integrating juvenile justice reform into the broader rule of law and development agendas. And not only because investing in juvenile justice reform means complying with international human rights obligation and, of course, investing in the future of our children, but also because, as Anne mentioned, studies have shown that investing in measures to promote child-friendly juvenile justice systems is cost-effective and results in return of investment. But there is something very important that we need to talk when we talk about juvenile justice. And that is the fact that despite a lot of progress achieved to date by many countries, quite often juvenile justice reform has been implemented through the adoption of fragmented approaches. For example, some countries have focused exclusively on the development of legislation and policies without paying due attention to the need to build the capacities of juvenile justice professionals. We also see countries which have invested a lot of their resources on building the capacity of juvenile justice professionals, but have neglected the establishment of institutions, of specialized institutions, and the provision of resources for the trained and new skilled professionals to effectively perform their duties. We also see many countries that have developed excellent legislation, have put in place very good policies, institutions, and procedures, but have not paid enough attention to the need to promote coordination and collaboration between relevant juvenile justice institutions and actors. And we should not forget those countries that invested a lot on what we call the supply side of juvenile justice by strengthening juvenile justice institutions, but completely neglected the need also to strengthen the demand side of juvenile justice, which in other words means creating the conditions for children and families to be able to exercise and claim their rights, promoting legal aid for children, and fostering the engagement of media and civil society to support juvenile justice reform process. So the bottom line is, if we are to promote effective and sustainable juvenile justice reform, we must change the current paradigm and shift away from the fragmented approach to a systemic approach to juvenile justice reform. Juvenile justice reform should be embedded in processes of long-term institution and policy reform. As it was mentioned before, it should be child rights-based, and countries should place a strong emphasis on promoting crime prevention measures and the accountability of justice institutions. Countries should strengthen child protection systems and foster the coordination between child protection, health, education, and justice systems. Coordination and collaboration should be promoted not only between government and justice institutions, but also between state and non-state actors. Communication and advocacy measures aimed to promote the engagement of media and civil society are essential in promoting positive change. Finally, formal and informal mechanisms should be instituted for children to participate in the development and implementation of laws, policies, and programs aimed to promote juvenile justice reform. In conclusion, I would like to say that the year 2015 will mark a historical moment for the international community. With the introduction of the 2015 Development Agenda, Member States are manifesting their commitment to democracy, good governance, and the rule of law. Global juvenile justice reform should definitely be part of this commitment. On behalf of UNODC, I would like to mention that we will continue to address our efforts to support Member States in their juvenile justice reform efforts, and we look very much forward to joining hands with all of you in this endeavor. Thank you.
Je crois que Mme Martins nous a parfaitement démontré quelle place occupe la justice juvénile dans le système global de justice et nous l'en remercions. C'est le moment maintenant de faire une pause. D'abord, j'aimerais bien prier les intervenants du bloc suivant de venir devant maintenant et de nous contacter. Nous continuons avec les discussions à 11 heures. Merci beaucoup pour votre attention.
So, if you allow me, Mrs. Julia Slot-Nissen, Judge Andrew Beecroft, Mrs. Regina Jensdottir, and Mr. Fernando Ferrero, please, we would like to see you here for a few seconds, few minutes during the pause. Thank you very much.